Good morning, students. Today we'll be dealing with the topic General Provisions of Transfer of Property Act 1882. Understanding this general provision is very important for the reason that under this general provisions we would find certain things which would help us to understand how the Transfer of Property Act deals with the transaction in relation to immovable property and whether all the provisions are relation to immovable property only or to some of the provision the movable property also comes under. So that is to say we will be dealing today the general provisions which has been provided under section 5 to 9 of Transfer of Property Act 1882. So if we talk about this particular general provision, then in that case, we would come to know that whatever the transfer takes place under Transfer of Property Act are the transfers which are done by the act of the parties. Because in our earlier lectures, as we have already studied that the Transfer of Property Act only deals with the transfer relating to the properties which takes place between two or more living persons. It is not necessary that these living persons may be a human being, but these living persons may be companies, may be associations, or may be a body of individuals or a firm or a corporation like that. But one have to keep it in mind that under Transfer of Property Act, only those transfers which takes place by the act of parties are covered. That is to say, only the inter vivos transfers. Now, if we take into consideration the scheme of Transfer of Property Act, we would come to know that there are two parts in it, Part A and Part B. While going through Part A, we find that Part A provides for rules regarding transfer of property in general. That is what we were talking about. The Part A provides for rules regarding transfer of property in general. This inclusive of both types of properties. First, the immovable or the immovable. Now let us come to Part B. What does Part B provides? Part B of Transfer of Property Act provides the rules regarding transfer of immovable property. Now students, we know that Part A deals with the rules regarding transfer of property in general. In general, in the sense whether it is movable or immovable, there are certain rules which need to be complied for the successful completion of transfer of property between living persons. Part B is more specific in nature. It says that Part B of Transfer of Property Act, by virtue of which only the transfers which takes place by the act of parties are covered, and Part B more specifically deals with the rules regarding transfer of immovable property only. Now students, you have to keep it in mind. Part A deals with the transfer of property, may be the movable or may be immovable, whereas Part B deals only with the rules regarding transfer of immovable property. Now let us see Part A. When we say that Part A deals with the rules which are in relation to transfer of property, whether movable or immovable, what is that? What is provided under these basically Part A? First, it deals with the general provisions. What may be transferred? Competency of the person to transfer a property, the competency of transferor and the transferee, the operation of transfer and the oral transfer. This is what is covered under the head general provisions. These are the general rule regarding what may be transferred, who are competent person to transfer the property, who is competent transferee, how the transfer takes place, that is to say operation of transfer, and whether the oral transfer is allowed under Transfer of Property Act. Second point which we will be seeing under this part A is a restriction on transfers. Now, whenever a person transfers a property to the another person, then in that case, whether there is any kind of restriction which prohibits the alienation of property from one person to another, that is what we are going to see. Next is transfer for the benefit of an unborn person. Now, students, unborn person, knowing what do we mean by the term unborn person is important. Unborn person is a person who is not yet conceived. Then in that case, whether a property could be transferred for the benefit of such unborn person, if yes, then in that case, under what circumstances and by keeping in mind what principles, that is to be studied by us in this head. Next is transfer to a class. Next is vested interest. Now, whenever students we transfer a property to the another person, that is to say the transferee, gets a kind of interest in that particular property. That kind of interest may be a vested interest, may depend upon certain contingency. If it is a vested interest, then in that case 0.5 would be, it would be covered by 0.5. If suppose we talks about that it depends upon certain contingency means what? It may happen or may not happen, certain future uncertain event, some future uncertain event. On the basis of that, if we are going to get any interest in the property, then in that case it would be called as a contingent interest, which depends upon the happening or not happening of any uncertain future event. Students, if the future event is there and it is of certain in nature, it is bound to happen, bound to take place, then in that case it would be called as a vested interest. Only the enjoyment in that particular property is postponed, but the interest is already created and it would be called as a vested interest. But suppose if the event is future and also uncertain, then in that case it would be called as a contingent interest, and hence it depends upon the happening or not happening of any future uncertain event. Next is the conditional transfer. Whenever a person transfers a property to the another person, he may transfer it without condition, he may transfer it without any condition. Suppose if he transfers it without condition, the other person would get a right, immediate right over that particular property. But suppose if a condition is attached to it, then in that case, only on the fulfillment of that particular condition, the transfer is going to get a right over that particular property. But again, it is also important that whatever is condition attached to the transfer of the property, that particular condition need to be a lawful condition, need to be capable of being performance, need to be not against statutory provisions, need to be not against a public policy. So whatever the condition is attached, then in that case that particular condition is lawful or not. That is also very important. If it is unlawful, then in that case that condition is void, but the transaction is valid. But suppose if the condition is valid, then in that case, firstly, unless and until the condition is fulfilled, the person, that is to say the transferee, is not going to get a interest, any kind of interest in the property. Next, students will be studying under this particular part is the election. Here, election does not mean the same which we actually knew. That is, election, it is not something like a political election or something like that, but election here means choosing between two things, choosing between two things. Again, in general, what we opt for, whatever the thing we find it to be good to us, we opt for that particular thing, and we leave the thing which we do not find to be useful to us. Actually, it is not a election under Transfer of Property Act. Under Transfer of Property Act, the election provision deals with a statement wherein one statement itself have two aspect, one the positive aspect and the negative aspect. You cannot break that particular proposal here. You cannot break that particular proposal in two parts, and you just will be obeyed by only a one part which is beneficial to you and the another which is not a beneficial one to you. But here, if it is framed in such a fashion wherein if you want to accept, you have to accept it wholly, you have to accept it entirely. And suppose if you do not accept it, or if you say that I do not want to have this proposal to be implemented on me, then in that case you will be losing all the benefits coming out of that particular proposal. So that is to say, you have to choose either to take the proposal or not to take the proposal. That is the only basically choice available to you under this particular head. Next one is the apportionment. Apportionment again too is very important. So far as the Transfer of Property Act, we would be dealing with whenever we'll be dealing in detail with this particular part one by one point. And now students, as we knew that in part one there would be total 9 topics we would be studying, right? Now come to the general provisions, section 5 to 9. Now, what does section 5 says? Section 5 deals with the transfer of property definition. But the students, here actually the transfer of property is not defined, but it has been defined in the various ways by which we can transfer property from one person to another, and how we will be transferring it. But actually there is no definition of transfer of property being given over here. Now let us see what has been provided under section 5, definition of transfer of property. Students will be always receiving very first question in exam paper as to define the term transfer of property and discuss in detail what property may be transferred and what may not be transferred. So first, in today's lecture we'll be dealing with the very first part of this particular question, that is to say section 5, definition of transfer of property under Transfer of Property Act 1882. Students, it is nothing but an act by which a living person conveys a property in present or in future. So, what has been provided that it means it is an act by which a living person conveys a property in present or in future to one or more other living persons, or to himself, and one or more other living persons, and to transfer a property is to perform such act. Now we have to keep it in mind, this particular definition deals only with conveying the property. This is in relation to conveying the property. It does not define what do we mean by the term transfer of property, but the definition it relates specifically to conveying the property from one person to another. We may convey the property in present also. We may convey the property to take place in the transaction to take place in future, or will be transferring the property present in present itself, but the person in favor of whom we have transferred the property would be in a position to enjoy that property in future. That is to say, here it means that an act by which a living person conveys a property in present. Immediately I am transferring a property in your name is an example of this particular sentence. Later on, it has been said that it is an act by which a living person conveys a property in future. That is to say, I'll be transferring a property, I will be transferring a property presently, but I'll put a future date wherein you will be in that future date is going to get a property. So this would be covered under this particular definition. Now, the transfer must take place between one or more other living persons. Important is there has to be one or more other living persons. Next is the person may transfer a property to himself also. He may himself, the owner of the property or the transferor of the property or the person who is authorized to transfer, may transfer the property to himself also, or to himself and one or more other living persons, and to transfer is to perform such act. He may transfer that property to himself as well as along with the other two or more of the living persons. So he may transfer the property to himself, he may transfer the property to one or more of the other living person. Third one is he may transfer the property to himself and one or more other living persons. When a person performs such kind of an act, it is called as a transfer of property. So far as section 5 is concerned. In this section, living person means what? Living person includes a company, association, or a body of individuals. Whether they are corporate or not, it hardly make any difference. But nothing herein contained shall affect any law for a time being in force relating to transfer of property or by companies, association, or a bodies of individual. Now students, because we knew company, association, or a body of individual have been declared to be a juristic person, they are nothing but a legal person, and like the individual have their name, signature, seal, likewise the companies, associations, and body of individuals have their name, signature, seal, right to acquire the property, right to transactions, right to hold the property. And on the basis of this, even these companies, associations, and body of individuals are covered under the head living person. So, not only the human being, but also a company, there could be a transaction between human being to human being, there could be a transaction between human being and company, or a body of us individual or association, whether they are registered or not registered, it hardly make any difference. There could be a transaction between one company or the other living other company, or one company with the association, or one company with the body of individual. There could be any kind of such a match which would be covered under the transfer of property act. Now students, there is somewhat question comes in my mind that on the basis of this I can come to certain conclusion. Whatever I've studied, I can come to certain conclusion. What is that? The transfer of property is an act of conveyance. Conveyance means what? Alienation, transfer from one person to another. It does not simply means a transfer, but it simply means transferring a legal title. Conveyance means what? Transferring a legal title from one person to another relating to any particular property. So here transfer of property is nothing but an act of conveyance. It is an act of conveyance. Why we are saying it is an act of conveyance? Because by virtue of entering into a transfer of property deed, what we are doing is we are transferring a legal title from one person to another, and that particular transaction is called as a conveyance so far as transfer of property act is concerned. Now second important thing is the conveyance is affected through living persons. Important is what? This living persons. Now this living persons could be human being, could be companies, could be corporations, could be associations, could be body of individuals. Now next is property may be conveyed either to one or more other living persons, or to himself, or to himself with one or more other living persons. Now students, it does not mean that on both these sides there has to be a human being only. There one side there could be a human being and a company, and the other side the human being or the other companies, or maybe only the sole companies, or maybe the corporations or body of individuals. Whatever you wish to actually match for the purposes of your understanding, you can match it, and the same would be covered under the head transfer of property act, the transaction wherein the property is conveyed from one living person to another, because all of them are covered under the living persons. Living persons is inclusive of all the legal persons and the juristic persons. Now, fourth one is property may be transferred within future or in present. So, property may be transferred in present also by making an immediate or by creating an immediate interest in that particular property in favor of someone. We can in present transfer the property to particular person. We may even transfer presently the property, but which would take place in a future. Likewise also we can transfer the property, so whosoever is the transferer would on that particular date would get a right to enjoy that particular property which was already vested in him in the prior date. So, likewise, the property which may be transferred may take place in present as well as in future. Now, the students, once we are saying that property may be transferred in future or in present, one have to keep it in mind that whenever we talk about a property which is going to come in future, which is going to come in future, presently we do not have that particular property, but which is going to come in future to us, at presently we cannot transfer that particular property. So the property which we do not have at present, either in the form of a possession or in the form of ownership, we cannot transfer that property. But suppose if we make an instrument, a legal document by virtue of which we are transferring a property which we do not have at present, then in that case that particular kind of property the transaction would be termed to be a void one. But if suppose we have a property at present, and if your father makes a deed wherein he says that you are going to get a property only after you complete your 21 years of age, then in that case you are at present, take an example of 18 years, so you'll be getting, you though may have a vested interest in that particular property, but you are going to get a property only after you attend the age of 21 years. So till the time your enjoyment over that particular property is postponed, but it would be considered that the transaction is valid one and your father has made a valid transaction in your favor. So property may be transferred within future or in present. Now, if we take into consideration the act of conveyance, transfer of property is nothing but an act of conveyance. So, let us now try to understand it in a more better way. The act of conveyance means what, or what happens under the act of conveyance? The property must be handed over to other person. The conveyance, where what we are saying is there is a transfer, there is an alienation, and alienation is in respect to what? Title. The title is to be handed over from one person to the another, or any kind of interest in that particular property need to be transferred from one person to the another person. Then in that case the act of conveyance means the property must be handed over to the other person. Second one is, it is anyone, not necessarily the owner of the property must convey the property. It's not necessary that only the owner is having a right to transfer the property. Any other person to whom the owner has authorized, for example, if an agent is authorized, then in that case anyone who is having a right on behalf of the owner to transfer that particular property would be in a position to transfer that particular property. So here means the property must be handed over to the another person, that is to say it must be conveyed, it must be transferred, it must be alienated from one person to the another. This alienation or conveyance could be done by anyone who is authorized to do so. And third one is, it is not necessary that all the rights or interest in the property must be conveyed to another person. So students, it is not necessary only in the sale. Take an example, only in the sale what happens, we transfer the entire right in the property. But suppose if we are creating a lease, then only in then in that situation we only transfer the possession of property, but the ownership of the property still remains with us. After some period we can claim back our property back. Similarly, in the suppose if we I suppose if I transfer you a mango tree, if I transfers you a mango tree saying that okay, I transfer this mango tree to you provided you just take care, do not eat any kind of do not eat mango from that particular tree, then in that case I have just handed over the mango tree to you so that you can take care of that particular mango tree, but I have not authorized you to eat the mangoes which are actually coming out of that particular tree. So in that situation, it is not necessary that all the time we'll be transferring all the property rights over that particular property to some another person. We may refrain or we may limit the rights, because over any particular property we have a bundle of rights, not only to be called as a owner, but also to be also to use it in a way we like, the right to dispose of, right to allow anybody to come and enjoy in that particular property. So there are n number of rights which we acquire over any particular property. So under transfer of property act, it is not necessary that only the person can transfer. Whenever transferring a property, have to transfer the entire right over the property. He may keep somewhat rights available, limit to himself, and he may transfer one or two of the right to other person. So he may transfer the entire rights also, he may transfer some of the rights also. Both the situations are covered under transfer of property act. For the reason, under transfer of property act we'll be studying a sale, wherein all the rights one must transfer from one person to another person, so that another person can get a full enjoyment of that particular property. We will be also dealing under this particular act the sale, the mortgage, the lease. So far as mortgage and lease is concerned, the transferee have only a limited right over that particular property. So I have given you both the instances, both the examples. The sale wherein all the right relating to the property is transferred, and a lease and mortgage are there wherein only a limited rights are transferred from one person to another. So it is not necessary that all the rights or interest in the property must be conveyed to the another person. The transferee must not have a title to the property conveyed, or must not have some interest already in the property, so conveyed prior to its conveyance in his favor. Now student, this again is very important line. I have underlined it. What does this mean? Whenever a transfer takes place, there are two parties. One, the transferor who transfers the property to the transferee, and the another person is called as a transferee, who is going to get a property in that by virtue of that particular transfer. Now, students, the transferee must not have a title to the property conveyed. Whatever is the subject matter of transfer, if already been owned by the transferee, what is the use of conveying that particular property to him? And if suppose we convey later on that particular property to a owner himself, then in that case it would not be covered under the head transfer of property, because it is always a transferor who may make a transfer of that particular property. For creating a transfer of that particular property, the other person must not be having any kind of interest or any kind of title over that particular property which we are going to transfer in his favor. Suppose if it is already there, then in that case it is okay. But if it is not there at the time of conveyance, then in that case one must see that the transferee must not have a title to the property which is conveyed, or must not have same in some interest already in the property, so conveyed prior to his conveyance in his favor. Whenever we are making a deed, at before making a deed, this particular transferee should not have any kind of interest. If he is having any kind of interest, then in that case that particular transaction is not going to take place under the transfer of property act and would not be considered to be a valid transfer. If it is so, then it would not be considered as an act of conveyance, because if it is there, the transferee is having somewhat a right or interest in that particular property, then in that case it would not be considered to be an act of conveyance. Now, let us see, students, there are important ways by which conveyance takes place under transfer of property. First, the sale. The another one is mortgage, lease, exchange, and gift. These are the five ways by which the transfer of property takes place under this particular act. Now, we have said that the property must be conveyed by one living person to another living person. We have already gone through what we mean by the term living person. It includes the individuals, it includes the companies, whether corporations, whether they are corporated or not. And third one is the association or a body of individuals to whom the property may be transferred. Now, the students, important to know about the conveyance by living person. Both the transferor and the transferee must be living at the time of the transfer, because If one party is not living, then in that case the transferor is not the transfer is dead, then in that case such kind of a property, such kind of a transaction cannot take place. For transaction to be take place under this particular act, what is important, there has to be a inter vivos transfer. Now it is also applicable to a legal person, that is the corporation, companies, firms, idol, deity, etc., because they've been considered to be the living person so far as the transfer of property act is concerned. The third one is a dedication of the property to a deity does not come within the purview of this act, for the reason the deity may be turned out to be a living person or a juristic person, but again dedication to the property is covered by some different act and not by this particular transaction and transfer of property act. Now again the court is not a juristic person, we have to keep it in mind that no property could be transferred in by way of transfer of property to the courts. The court order for a sale is not a transfer of property within the meaning of this act. Now, students, conveyance to himself or himself with one or more of the other persons. Before passing of the Amendment Act 1929, the transferor could transfer his property to other living person or to himself and one or more of the other living person, and not to himself alone. But after passing of the Amendment Act, now he can transfer his property to himself also. Now, if we take into consideration what was there provided under transfer in future or in present, the term present or in future is in relation to conveyance, as we have already discussed. The transferor may transfer the property either with the immediate effect, that is to say, vesting of interest is an immediate effect. The transferor may transfer the property to be effective from a future date. In this case, the vesting of interest in the property is postponed to a future date, as we have already discussed. So, students, I wish you have understood the concept very well. We have completed section 5, and in the coming time, we will be in the next lecture, we'll be dealing with what property may be transferred and what may not be transferred. I hope you have understood the things, and I wish you a very happy day